Hudson Valley Drunk Driving Defense for Physicians and Doctors. A single DWI arrest can threaten a Hudson Valley physician's career that was built on decades of relentless dedication and sacrifice. While the immediate fear centers on losing a medical license, an arrest alone does not automatically end your ability to practice medicine. A conviction, however, triggers a strict professional investigation by the Office of Professional Medical Conduct alongside your criminal case. Surviving both the criminal charges and the licensing threat requires a highly strategic defense that begins from the very first day. Randall F. Inniss is a former New York State trooper and certified breathalyzer operator who knows exactly how police construct DWI cases from the inside. Having personally made and participated in over 100 DWI arrests during his law enforcement career, he understands every step of the process that now stands against you. As a seasoned New York drunk driving lawyer for licensed professionals, he aggressively fights your criminal charges in court while simultaneously protecting your medical license. New York law creates a spectrum of impaired driving charges under Vehicle and Traffic Law, Section 1192, ranging from a traffic infraction all the way to a Class 500 felony. A DWAI charge applies when your BAC falls between 0.05 and 0.07. And while it is classified as a traffic infraction, it still carries serious professional consequences for physicians. A standard DWI charge requires a BAC of 0.08 or higher, while an aggravated DWI applies at 0.18 or above and carries significantly harsher penalties. A second DWI conviction within 10 years becomes a Class E felony, and a third within 10 years escalates to a Class 500 felony, with the highest likelihood of full license revocation. New York law does not require physicians to immediately self-report a DWI arrest to the OPMC, but a criminal conviction must be reported within 30 days. Courts are legally required to notify professional licensing boards upon conviction, making this notification process largely automatic and independent of your final criminal outcome. The OPMC holds independent authority to investigate any physician whose conduct raises questions about fitness to practice, and it can act even when criminal charges are reduced or dismissed. Even a non-criminal DWAI may constitute professional misconduct if the OPMC determines it reflects on a physician's fitness, meaning no charge is truly minor for a licensed doctor. The attorney you choose must understand both the criminal courtroom and the medical licensing board with equal depth and precision. Call the Inniss firm, PLLC, located at 280 NY-211 Ste, 203, Middletown, New York 10940, at 845-470-4236 to schedule your confidential consultation and protect everything you have worked for.